Assalamualaikum warahmatullahi wabarakatuh. My name is Huda binti Abdul Rahman and I'll be going to present on the background of Boshiwa and the first issue of the case study. Moving on to the background of the company of Boshiwa. Boshiwa or Boshiwa International Holding Limited is a Chinese organization that had developed and sells children's products. It has incorporated since 1997. In 2005, Boshiwa has registered its own brand Dr. Frog in Hong Kong and Japan. Then they expand the organization from producing self-owned brand to carrying licensed brands such as Harry Potter, Bob the Builder and Manchester United. On 15 March 2012, Deloitte, the auditors of Boshiwa, had resigned with immediate effect, and this had led Boshiwa announcing a delay in releasing their fiscal year 2011 earnings due to the need for a new auditor and formation of a special investigation committee to look at the issues raised by Deloitte. On 5th April 2012, Boshiwa established an International Special Investigation Committee (SIC) consisting of all three independent non-executive directors to investigate the matters raised in Deloitte's resignation letter and make recommendations to the board on appropriate actions to be taken. On 8 November 2012, PwC had been appointed as an independent professional advisor to carry out the forensic investigation and compile the investigation report for SIC to enhance the transparency of information to shareholders and investors. On 26 April 2013, PwC's investigation report of Boshiwa was released, where there was a large number of original records relevant to the investigation were unavailable, with only copies of those documents available for review. On 11 February 2015, there has been a petition for Boshiwa's winding up. On 3 November 2020, the organization announced its departure as the listing companies in Hong Kong Exchange. The issues that our group came out in Boshiwa case studies is first, ineffectiveness of board composition, second, accounting scandal, third, resignation of auditor, fourth, poor corporate governance. Moving on to the first issue, which is ineffectiveness of board composition, where there is no separation of positions between chairman and CEO. The discussion question for this issue is, what are the responsibilities of chairman and the chief executive officer, and whether the position of the chairman and the chief executive officer can be held by the same person and the rationale behind it. The discussion objective for the first issue is to identify the responsibilities of chairman and the chief executive officer and to clarify whether the position of the chairman and the chief executive officer can be held by the same person and the rationale behind it. Moving on to the literature review of the first issue. The first one is chief executive officer. According to Bursa Malaysia listing requirement, chief executive is a leading executive officer of the corporation or whether he is a director. Second one is chairman. A chair is an executive that was elected by board of directors and it is responsible in presiding for the board or committee meeting. The third one is responsibilities of COO. The CEO is responsible for performance of the company as determined by the board's strategy and report to the chairman or board of directors. The fourth one is responsibilities of chairman, which is according to the guidance to practice 1.2 of MCCG 2021, responsibilities of chairman is to lead the board and implement a good corporate governance practices in the company. Next literature review is on the separation position of CEO and chairman. According to practice 1.3 of MCCG 2021, chairman and chief executive officer position is held by different person. According to practice 1.4 of MCCG 2021, chairman of the board cannot be a member of the audit committee, nomination committee or remuneration committee. The third one is according to appendix 14 of A.2.1 of Hong Kong listing requirement. Chief executive and chairman roles should be separated and thus not performed by the same person. The last literature review of the first issue is the rationale of separation of positions. According to guidance to practice 1.3 of MCCG 2021, separating position of the chairman and CEO will make the allocation of responsibilities between the two positions easier, in which no one can influence the board's decision making. Moving on to the next part, which is application. By applying practice 1.3 of MCCG 2021, chairman and the chief executive officer position must be held by different person. And by applying appendix 14 A.2.1 of Hong Kong listing requirement, chief executive and chairman roles should be separated and does not perform by the same person. However, we can see in the case study where the chairman of Boshiwa, Mr. Zong Zeng Yong, is a chief executive officer as well as chairman of the new nominating committee, which this clearly shows that Mr. Zong Zeng Yong has breached the compliance of corporate governance based on the MCCG and Hong Kong listing requirement, whereby the position of chairman and CEO is held by the same person. This can be briefly explained whereby if Mr. Zong Zeng Yong holds the position of chairman and CEO, as mentioned in guidance of Practice 1.3 of MCCG 2021, it can influence the decision-making of the board. Furthermore, the second issue of the board composition is where Mr. Zong Zeng Yong, apart from being the CEO and chairman of the nominating committee, he also a member of remuneration committee, whereby this has contradict with practice 1.4 of MCCG 2021, which stated the chairman of the board cannot be a member of the audit committee, nomination committee, or remuneration committee. Moving on to the next part, which is recommendation. For the first issue, our group came out with the solution or recommendation on the nomination committee, whereby the nomination committee must evaluate and investigate beforehand to ensure that there is no repetitive position of the CEO and chairman. Furthermore, the nomination committee should also provide detailed explanation on the responsibilities of each respective positions before appointing CEO and the chairman.
Assalamualaikum, my name is Nur Karunisa and I will be presenting the next issue, which is accounting scandal. Upon further checking, we identify an issue related to fraudulent statement and fictitious amount of profit discovered. Discussion question. What is the measure of transparency should be practiced by the management to enhance the integrity and honesty in monitoring company funds? Discussion objective. To identify the appropriate action that should be taken by the management in the regulatory and monitoring of the practices of corporate governance ethics among the management. Moving on to the literature review that is related to the issue, which is the first one, Corporate Governance Core Concept, MCCG 2021 Guidance 1.1 that state all directors must act with integrity, lead by example, keep abreast of his responsibilities as a director and of the conduct of the business activity and development of the company. Next is Corporate Governance Core Concept, MCCG 2021 Guidance 4.4 state that the performance evaluation should be conducted to promote accountability and identify issues that may require intervention by the board or senior management, which is related to the organization financial statement. Next, Good Corporate Governance MCCG 2021 Guidance 4.1.1, where it states that the board should understand that the key principle of good corporate governance, such as effective control, corporate culture, grounded on ethical behavior and transparency, that can reduce risk, corruption, and mismanagement. Next, in Companies Act 2016, Section 249, Subsection 1 state that the annual financial statement for a financial year should give a true and fair view of the financial position at the end of the financial year. Moreover, in Companies Act 2016, Section 266, Subsection 8A, if an auditor in the course of the performance of his duty as auditor of a company is satisfied that there has been a breach of non-observance of any of the provision of this Act, he shall report the matter in writing to the registrar. Based on the literature review, the application of its regarding this issue can be analysed whereby when the management claim that the inventory balances increased despite having increase in number of store and promotion. They also claim that the cash surplus amounting 18 million have been recorded in their financial statement. These behavior are contradict according to MCCG Guidance 1.1 and the Guidance 4.4 as the director are liable to act with integrity of his conduct and also promote accountability in identify the issue. Next, the transactions stated in the financial statement are fictitious, where there are certain transactions are not accurate as it mentioned. The revenue and profit increasing, but the cash flow are negative. This issue contradicts with Companies Act 2016, Section 249, Subsection 1, where it states that the financial statement should give a true and fair view of the financial position. Lastly, upon further checking, have been detected that there are unethical accounting practices where there is fraudulent statement mentioned, such as there are 13 million unidentified profit from supplier have been recorded and the organization unable to provide the procurement contract. This is contradict with principle of good corporate governance, where the director should have ethical behavior and transparency in doing their responsibility. This also contradict with Companies Act 2016, Section 266, Subsection 8A, where upon discover there are fraudulent statements, should audit committee report that to them immediately. Lastly, for the recommendation, auditors should have high integrity and accountability behavior in doing their tasks. They are liable with their responsibility to ensure that the statement given are accurate and according to standard procedure. The management must ensure that the statement given are true and have a fair view from any fraud or any misleading statement. Next, the committee involved should always practice the rules and regulation in ensure the honesty in monitoring their company fund. Lastly, the management need to be transparent and not affecting their decision toward of their stakeholder, including their directors.
Assalamualaikum, I bid to Madam May and my fellow classmates. My name is Fatin Amira binti Muhammad Sofi. I will further explain on the third issue of the case study Boshiwa. The third issue of the case study is resignation of auditors. In March 2012, auditors of Boshiwa, Deloitte resigned due to the corporate governance issue and postponed in publishing the financial report in which this is considered breach the Hong Kong Stock Exchange listing rule. The resignation of the external auditor gave warning signal where investors value the company based on the public statement. But if the public statement cannot be trusted, how can investors value the company? The discussion question is, what are the responsibility of an external auditors and audit committee for a company, and how board audit committee and external auditors of the company should respond and manage any risk occur from the poor of corporate governance. For the discussion objective is to identify the role and responsibility of audit committee and external auditors in managing risk of poor corporate governance in the company. Moving on to the literature review, where we will look from the aspect of the roles and responsibility of audit committee and external auditors for the company. So, what is the external audit? According to accounting standard, external audit is a review conducted by an independent auditor. This type of audit is most commonly intended to result in the certification of an entity financial statement. Meanwhile, for the audit committee, it is an important part of the governance structure and operate under the board delegated authority. The roles and responsibility for external auditors is to detect, report, independent and integrity as external auditor. According to Zager, responsible to gain and provide rational or guarantee that the financial statement is being prepared properly. Next, external auditors also must report on the state of the company financial situation and certify the validity of any financial report that have been issued. Most important thing is throughout the auditing of financial statement, the auditor must be reasonable and professional in the auditor incredulity. Next, we move on to audit committee. Generally, audit committee play a vital role on the two main aspects, which are financial report and regulatory report. It is very important for audit committee to monitor the independence of the statutory auditor and oversee the company's internal control system and ensure compliance with law and regulation. According to Crescent, the rules and responsibility of audit committee is to monitor the process of financial reporting and effectiveness of the internal control. And at the same time, the audit committee must be responsible to oversee the firm financial performance and the report reliability. According to Practice 9.3 of MCCG 2021, Audit Committee also must safeguard the quality and reliability of audited financial statement, and also to validate an appropriate level of observance in accordance with the Practice 9.5 of MCCG 2021. We move on to the application to the case study. Audit committee failed to oversee the management activities of the company as the external auditors resigned due to the corporate governance issue. Deloitte, as external auditor, should immediately report to the authority if he had sent any anomaly detection in the financial report instead of directly sign the resignation letter and postpone in publishing the financial report, which is considered breached the Hong Kong listing rule. Next, Deloitte should also explain on the resignation letter to be fully exposed to the shareholder. It is because it should be handled by the shareholder as to seek the approval by the shareholder. So it cannot be handled by the management. As to conclude the issue of Boshiwa, and audits issue in a corporate governance, they must be aware of the rules and responsibility to enable effective communication between the various groups, facilitating the full integration of the department and organization. Lastly, to strengthen the monitor activities about the performance and effectiveness of the internal control system, where it can help to detect any issue and fraud or manipulated occur in the company. That's all from me. Thank you. So next, we will proceed to the next issue.
Assalamualaikum. I am Amira binti Ibrahim and I will presenting the last issue in the case study. The last issue, which is poor corporate governance. This issue focus on board of Boshiwa, unable to demonstrate the best behavior in managing the organization. Discussion question reads as what correlation that might arise if organization practicing an effective corporate structure within its shareholding structure and the relationship between the shareholding companies. And the discussion objective for this issue is to identify the extent of compilation when organization applying an effective corporate structure and effect of having personal interest with its shareholding companies. For literature review, our group managed to point out few matters. Firstly, Malaysian Code of Corporate Governance 2021 Practice 2.0 told that the board committees and management each have their own distinct rules and all of these parties have clear authority among them. Moreover, the board should not abandon its responsibility and should always keep a close eye on the board committees and management in ensuring the element of responsibility is held. Hence, it is important for the board to distribute the responsibility properly to verify that the board's ability to carry out its duty. Next one is Section 213 of Companies Act 2016 provides that the director must always use his power in conformity with this act for any intended purpose and in good faith in the best interest of the corporation. Besides, to give solid governance advice, strictly adheres to laws and regulation and support the development of corporate governance best practices, the board is assisted by a suitably qualified and competent company secretary is what had been stipulated under Malaysian Code on Corporate Governance 2021 Practice 1.5. Company secretary is advisable to think wisely in adapting the way of his work based on the board terms of reference and industry best practices. Furthermore, in aspects of internal control, Malaysian Code of Corporate Governance 2021 Guidance 10.1 stated that the board could perhaps design a risk management and internal control framework that is functional. Moving on to the next area, Malaysian disclosure requirements has been retrieved from Clearstream, a Central Securities Depository CSD company, retrieved that in their web page that Financial Reporting 11.3 of Bank Negara Malaysia stated that an institution had to follow these few guidelines in disclosing materials. One of the rules is the materials ought to be provided in timely manner and always update the rules when disclose the information. Moreover, Bank Negara Malaysia emphasised that the details should be sufficient to make sure others can comprehend well and can be utilised by others too. There is also Hong Kong Due Diligence Guideline. In Hong Kong Due Diligence Guideline 1.2.10, a key person would execute due diligence on the board's understanding of RIA and the listing responsibility, as well as an evaluation of the organisation accounting and management system. Through the assessment, the key person will determine two aspects, which are first, whether the organisation had complied with the rules in listing, several other regulatory requirements, including financial reporting and notifiable and connected transaction disclosure reporting standard. And the second aspect is capacity of the board to make an accurate assessment of its organisation's financial status and prospect, both before and after listing. After that, Hong Kong listing requirements of 13.51 subsection 4 claim that if there is any changes occur towards its auditor or financial year end, the reasons for the changes and other matters have to be brought to the attention of holders of security of the issuer. Lastly, related parties transaction element is imposed in this case study also. Any transaction involving the acquisition or disposition of interest in securities or asset by a firm or any of its subsidiary from or to a related party is referred to as related parties transaction. Bursa Malaysia listing requirement 1.01 in chapter 1 provide the meaning of person connected, which the person could be the individual shall be a body corporate or the body corporate itself, or he is the director in which the orders, instruction or wishes of said person is subjected to or is obligated to follow, whether formal or informal behavior.
Assalamualaikum, my name is Nur Hidayatun Eminadia. In application to the Boshiwa case study, board is asked to process the best behavior in order to have effective corporate governance. However, the directors of the Boshiwa International Holding failed to acknowledge and perform their responsibilities as stipulated under the MCCG 2021 Practice 2.0 due to the failure of the board to act in the best faith when holding the positions, thus caused Boshiwa to suffer the problems of transparency. Besides, as according to the Practice 1.5 of MCCG 2021, the Secretary of Boshiwa should be the one who holds the responsibilities to advise the board regarding the implementations of the good corporate governance, especially the transparency of information to the stakeholders. The Secretary also is the one who have the access to ensure a proper statutory record is being recorded and available during the inspections of any authorized parties. There is also a lack of internal control activities within the internal control system in Boshiwa, since the documentations for PwC investigations is not conducted adequately due to the unavailability of the documents and failure in preventing other entities' interference in the ordinary course of the trading business. In fact, the delay in disclosing the resignation letter suggests that Boshiwa's board of directors did not take the situation seriously. Hong Kong listing requirements 13.51 also explain that if there are any changes in the auditors or the financial year end, the organizations must announce the reasons and also other associated matters, and shareholders should be aware of the changes in the firm. Therefore, the board of Boshiwa had breached its fiduciary duties, since board ought to ensure all the information provided by the outgoing auditor and also necessary information are included before releasing it to the Hong Kong Stock Exchange. Lastly, the discovery of payroll records relating to the former Boshiwa employees revealed that the company's management and previous subsidiaries were involved. Plus, it can be assumed that there were hidden transactions that occurred since there is a financial scandal within the organizations. And also, there is an existence of related third party that might assist in the organizations in which the former subsidiaries of Boshiwa have a personal interest in the management of the Boshiwa. Moving on to the recommendations, so by referring to the Hong Kong due diligence guideline, the key person from the stock exchange firm could perform interviews with a few parties like the board, senior management, accounting and financial reporting employees, company secretary, and any compliance officer in the organizations. And from the interview, the key person can determine their personal and group experience, credentials, and capabilities, as well as whether they are aware of their responsibilities under the listing rules and other legal requirements. To examine the internal control system and its integrity, an independent organization must be established. So the review's finding will be feedback to the relevant divisions and then be used to provide guidelines for the appropriate development and implementations of the internal controls. Besides, a director must attend training programs as part of the requirement during their tenure. For instance, the Companies Commissions of Malaysia (CCM) conducted specific programs for all the directors annually, and all the directors are required to complete a mandatory accreditations program, or known as MEP, and they must participate in the program within the time frame that has been provided. In a nutshell, a good corporate structure should become a priority within an organization to avoid any complications that might arise, such as lack of transparency of the disclosure of information and the act of the personal interest that should be eliminated whenever conducting any business activities. As a result, it is critical for all parties to plan in order to ensure a good corporate governance practices. And that's all from our group. Thank you.